In the previous section, we examined the preliminary title report and its critical role in identifying liens, easements, and encumbrances that affect property ownership. That document ensures the buyer receives marketable title and protects against hidden legal defects. Building upon that foundation, this section turns to another vital component of transparency and consumer protection in Arizona real estate: the seller's disclosure obligations. While the title report reveals the recorded legal condition of a property, disclosures reveal the property's physical and environmental condition as known to the seller. Together, they ensure that buyers enter into real estate transactions fully informed, reducing the risk of fraud, misrepresentation, and post-closing disputes. Arizona law requires sellers to act with honesty and good faith in disclosing all known material facts that may affect a property's value or desirability. A material fact is any condition or information that could influence a buyer's decision to purchase or the price they are willing to pay. Under Arizona common law and ARS, paragraph 32, 2153A, 3, a seller or licensee who fails to disclose a known material defect may face disciplinary action and civil liability. This duty is also reinforced by Commissioner's Rule R428-1101A, which requires licensees to protect and promote the client's interests while dealing fairly with all parties to a transaction. The Arizona courts have consistently affirmed that sellers cannot conceal or fail to disclose defects they know about. The landmark case, Hill v. Jones, Arizona Appers 1986, established that a seller's failure to disclose known termite damage, even if repaired, constituted misrepresentation because the condition materially affected the property's value. The court ruled that buyers have the right to rely on sellers to disclose facts not readily observable through reasonable inspection. This case remains the foundation of disclosure law in Arizona, emphasizing that silence about known defects can be as misleading as an outright false statement. To comply with these legal standards, sellers in Arizona use the Seller's Property Disclosure Statement, SPDS, a comprehensive form developed by the Arizona Association of Realtors, AR. The SPDS requires the seller to disclose known facts about 6 main categories: property ownership and use, building and structural issues, roof and mechanical systems, environmental and sewer systems, utility services, and other conditions such as flood history or neighborhood nuisances. For example, if a seller knows that the property's air conditioning system is failing, that termites have been treated in the past, or that the property has a history of flooding, these must all be disclosed on the SPDS form. Failure to do so not only gives the buyer grounds for cancellation, but may also expose the seller to legal action for fraud or misrepresentation. A crucial point is that sellers are only required to disclose known defects. They are not responsible for hidden issues of which they are unaware. For example, if a home's plumbing contains concealed corrosion that has never caused leaks and the seller had no reason to suspect it, they are not liable for non-disclosure. However, once a defect is discovered, such as evidence of prior repairs, inspection reports, or complaints from tenants, the seller must disclose it to all potential buyers. The law expects sellers to disclose known and observable conditions, but does not require them to act as inspectors or engineers. The SPDS also serves to document compliance and protect both the seller and the broker. Once completed, the form is delivered to the buyer early in the transaction, typically within 5 days of contract acceptance. The buyer then reviews the disclosures during the inspection period. If the disclosures reveal previously unknown issues, the buyer may cancel the contract or negotiate repairs under the terms of the purchase agreement. For example, if the SPDS reveals prior foundation movement or a history of water leaks, the buyer might request a structural inspection or a credit toward repair costs. Seller disclosure obligations extend beyond physical defects. Sellers must also disclose information about environmental conditions and external factors that could impact the property. This includes floodplain location, nearby landfills, hazardous waste sites, or airport noise zones. Arizona courts have interpreted these requirements broadly, ruling in Lombardo v. Albu, Ariziter Aptiers 1997, that sellers must disclose not only physical issues, but also surrounding conditions that materially affect property value or enjoyment. This could include neighborhood disputes, zoning violations, or pending assessments. Real estate licensees share in this duty of disclosure. Under Commissioner's Rule R4-28 1101B, agents must disclose all known material facts, even if they are not advantageous to their client. For example, if a broker becomes aware of prior flood damage or unpermitted additions, they must disclose this information to the buyer regardless of whether the seller has acknowledged it. Licensees are not required to investigate or verify every potential issue, but must pass along any facts they know or reasonably should know through observation or information obtained during the transaction. Consider a common example. A seller lists a Phoenix home with evidence of a prior roof leak that was patched but not professionally repaired. The seller tells the agent but chooses not to include it in the SPDS. The agent, aware of the condition, must still disclose it to potential buyers. If both remain silent and the leak resurfaces after closing, the buyer can file a claim for misrepresentation. Both the seller and agent could face liability, and the Arizona Department of Real Estate could impose disciplinary action on the licensee. Discussion. Why is Hill v. Jones considered a landmark case for Arizona real estate disclosure law? Answer. Because it established that sellers have a legal duty to disclose known material defects, and that failure to disclose can constitute fraud or misrepresentation. What is the primary purpose of the Seller's Property Disclosure Statement, SPDS? Answer. To ensure transparency by requiring sellers to disclose all known material facts that could affect the property's value, safety, or desirability, protecting both the buyer and seller. Why must real estate licensees disclose material facts even if it is not in their client's best interest? Answer. Because under Arizona's Commissioner's Rules, licensees have a duty of honesty and fair dealing to all parties, and must not conceal information that could materially impact the transaction. Review summary. Seller disclosure obligations in Arizona are a cornerstone of fair dealing and consumer protection in real estate transactions. The Seller's Property Disclosure Statement, supported by case law such as Hill v. Jones and Lombardo v. Albu, ensures that buyers receive complete and accurate information about the property's condition. Sellers must disclose all known material facts affecting value or use, including structural, mechanical, and environmental issues. Licensees are legally and ethically required to communicate any material information they know, even if it conflicts with their client's interests. Through these combined obligations, Arizona law upholds transparency, good faith, and fairness, helping buyers make informed decisions and reducing the potential for disputes and litigation after closing.